Good afternoon, my name is Marie Jones and welcome to the Changes to the Fair Work Act and their effect on employers webinar. I will be your facilitator for today's presentation. Throughout the course of the webinar, you may wish to ask a question. This can be done by typing a question in the space provided in the Questions tab. Upon receiving your questions, we will respond at the conclusion of the webinar. The webinar will be recorded and made available on the NECA YouTube webpage and later use and reference. Finally, I'd like to thank you for taking part in today's webinar, and on that note, hand you over to today's presenter, Gordon Jervis.
Thank you, Marie, and good afternoon, everyone. Thank you for attending. The subject of today's webinar is the Changes to the Fair Work Act 2009. The Act itself has been subject to a series of amendments since its coming into effect on the 1st of January 2010. It has traversed the incumbency of 4 Prime Ministers, 2 Labor and 2 Liberal. Given yesterday's announcement of an extra sitting of Parliament by Malcolm Turnbull and the foreshadowed double dissolution if industrial relations legislation is not passed by the Senate, there could be many more changes to the Act to come. I'll commence with a brief discussion of the background to the legislation. In November 2015, the government introduced legislation to amend the Fair Work Act in a number of respects. Those amendments had to be reduced to get the legislation through the Senate. The remaining measures bill containing those 6 amendments rejected by the Senate in November was introduced into the lower house on the 3rd of December 2015. That bill has not been enacted to date. The Fair Work Act implemented the Labor government's election policy of 2007. Significant changes over the previous Workplace Relations Act that it replaced included the introduction of 10 national employment standards, modern awards containing a further 10 minimum conditions, expanded right of entry entitlements, collective bargaining and enterprise agreements, greater access to unfair dismissal laws insofar as the 100 employee limit was reduced or removed. State governments ceded their industrial relations law making powers to the Commonwealth. So all employees, for example, in New South Wales are subject to the Fair Work Act, except for state government employees and employers. The Fair Work 2012 review into operation of the Fair Work Act by the Fair Work Review Panel, the first tranche of changes to the Act commenced on the 1st of January 2013. They included anti-bullying provisions, consultation over changes to rosters or working hours and awards and enterprise agreements, consent arbitration for general protections claims. In fact, the anti-bullying provisions actually started on the 1st of January 2014. In regard to unfair dismissal changes, previously an employee had 14 days to make an unfair dismissal claim and 60 days to make an adverse action claim. Other changes were that the cost can be awarded against lawyers or paid agents in unfair dismissal cases where proceedings have been maintained that have no prospect of success, for example. Other changes from the 1st of January 2013, the Notice of Employee Representational Rights that begins the bargaining process can only contain content prescribed by the Fair Work regulations and no other content. In Peabody and Morvale Proprietary Limited v CFMEU, the employer issued a how, where and when to vote info sheet stapled to the Notice of Employee Representational Rights. In evidence, he said that he regarded that notice to employees as part of the Notice of Employee Representational Rights. The court or the Commission held that in doing so he had amended the Notice of Employee Representational Rights and therefore the notice was invalid. Enterprise agreement amendments that commenced on the 1st of January 2013 included that a union official or union cannot act as a bargaining representative for employees who are ineligible to join the union. The employer can only make an enterprise agreement with 2 or more employees, and that was decided in AMWU and Ingham's. In a vote to take protected industrial action, no show of hands votes are allowed. Electronic voting is okay, and self-represented union members can vote. There are a number of family-friendly changes from the 1st of July 2013. The right to request flexible working arrangements and expanded unpaid parental leave rights, including concurrent parental leave to 8 weeks for partners of primary caregivers. The employer must consult with employees about requests to extend the parental leave beyond the initial 12 months. Special maternity leave provisions were changed, and there is no 12-month qualifying period for removal to a safe job. Other changes that occurred from the 1st of January 2014, there was an expanded right of entry entitlements over the location of meetings. Under those changes that were initiated by the Labor government in 2014, the lunchroom became the default venue for a meeting with employees who were members or eligible to be members of a union, if no other venue could be agreed between the employer and the union. In regard to remote sites, the employer was required to provide accommodation and transport arrangements for union officials when visiting those sites. The bullying jurisdiction, as I said, came into operation on the 1st of January 2014 and applies to all current workers. For it to be bullying to be established, the behaviour must be repeated and unreasonable and not reasonable management action. The Fair Work Commission cannot make monetary orders in resolving a bullying claim. It can make orders that the bullying cease or desist, or make other orders affecting how the employee works or reports to other people in the workplace. In regard to the bullying changes, it applies to all workers, and a worker includes an employee, a contractor or subcontractor, an employee of a contractor or subcontractor, an employee of a labour hire company who has been assigned to work in a particular business or organisation, an outworker, an apprentice or trainee, a student gaining work experience, and a volunteer. It applies to constitutional trading corporations throughout Australia, but it does not apply to partnerships or sole traders. The changes that started on the 1st of November 2015 and commenced on the 27th of November 2015, as I said earlier, did not contain all the changes wanted by the government contained in the report by the Senate's Education and Employment Legislation Committee. It did contain changes affecting Greenfields agreements, protected industrial action, unpaid parental leave, and another amendment where the Fair Work Ombudsman is required to pay interest on unpaid monies. That provision has not been as yet enacted, as it says there in the screen. As far as Greenfields agreements are concerned, the federal government wanted a 3-month maximum bargaining period. The amendment imposed by the Senate made that a 6-month bargaining period. So therefore, if no agreement can be made between an employer and an employee and the union within 6 months, the employer can take the agreement to the Fair Work Commission, and the Fair Work Commission must approve the agreement if it passes the Better Off Overall test and it contains pay and conditions consistent with those prevailing in the relevant industry. Unions can object to the approval of the enterprise agreement on the basis that the agreement either does not pass the Better Off Overall test or does not contain those consistent terms and conditions. And a right of appeal, of course, is maintained. As far as protected industrial action is concerned, the significant amendment is that unions cannot take protected industrial action before bargaining starts. And that was to overturn a decision in J.J. Richards and Sons versus Fair Work Australia, where the federal court had determined that even though the relevant union, the Transport Workers Union, had not commenced to bargain with J.J. Richards over the terms of a new enterprise agreement, and even J.J. Richards hadn't even agreed to make an enterprise agreement, nevertheless the union was at liberty to conduct a protective action ballot and therefore take protected industrial action. That amendment has remedied that position, and the position therefore is that the union and or the employees must be genuinely trying to reach an agreement before taking protected industrial action has been retained. As far as unpaid parental leave is concerned, all employees in Australia are entitled to parental leave. Employees are able to take parental leave if they have worked for their employer for at least 12 months. Before the date of the expected date of birth if the employee is pregnant, before the date of the adoption, or when the leave starts, if the leave is taken after another person cares for the child or takes parental leave. It can be taken by employees who have or will have responsibility for the care of a child. Casual employees are also eligible for unpaid parental leave if they have worked for their employer on a regular basis and systematic basis for at least 12 months and have a reasonable expectation of continuing work with the employer on a regular and systematic basis, had it not been for the birth or adoption of the child. An employee does not have to wait another 12 months to have another child to access the parental leave. So once they've accessed it once and they have a second child, then there is no 12-month qualifying period for that second pregnancy. Interest on unclaimed money, as I said, that hasn't been enacted as yet, but an employer can pay monies owed to the employees who cannot be located to the Fair Work Ombudsman. The Fair Work Ombudsman is to pay interest on amounts over $100 that have been held by more than 6 months. The government, as I said in the introduction, has introduced the remaining measures bill 2015 on the 3rd of December 2015. Those provisions, or these 6 provisions, have not as yet been enacted by Parliament, and they were previously removed from the amending act that came into effect on the 27th of November. The remaining measures bill contains provisions regarding termination of employment, accruing leave on workers' compensation, individual flexibility agreements, transfer of business, right of entry, unfair dismissal. As far as termination of employment is concerned, the National Employment Standards will say that payout of accrued and untaken leave must be at least equivalent to the employee's base rate of pay. An award or enterprise agreement can provide for more beneficial terms. It overcomes the anomaly, as it says in the slide, in the National Employment Standards where annual leave loading is included in an annual leave payout. Accruing annual leave on workers' compensation, the bill will make it clear that an employee cannot accrue or take annual leave during a period in which he or she is receiving workers' compensation. The explanatory memorandum to the remaining measures bill says that it ensures all employees in the national system have the same entitlements, but the legislation will operate prospectively. This comes about because in the Commonwealth, and that is in the ACT, for example, and Queensland, legislation says that employees accrue paid leave while on workers' compensation. And it's also the position in New South Wales under Section 49 of the Workers' Compensation Act, following the case New South Wales Nurses and Midwives Association versus Anglican Care. In regard to individual flexibility agreements, it's recognised that there has been a low take-up of individual flexibility agreements or IFAs. The bill says that an IFA in an enterprise agreement must, as a minimum, allow arrangements about when work is performed, overtime rates, penalty rates, allowances and leave loading. Previously, an enterprise agreement could have an individual flexibility agreement that only concerned itself with one matter, such as when work is performed or overtime rates. The IFA can also include any other matters that are agreed between the employee and the relevant employer. The employee must be better off overall, but the better off test is not restricted to monetary assessment. The IFA must include a statement by the employee about why he or she is better off. For example, the IFA may give the employee some flexibility in hours, even though they are not getting any more money, but the flexibility in hours suits their domestic or other requirements. At the moment, a transfer of business occurs when employees' employment is transferred from one employer to another and employers are associated entities. Currently, the instrument covering an employee at the old employer also transfers to the new employer unless the new employer makes an application to the Fair Work Commission. If the transfer under the amendments, if a transfer occurs at the initiative of the employee, his or her terms and conditions of employment will be those provided by the new employer. The employee's request to transfer must be before employment is terminated with the old employer. Continuity of service will not be affected. As far as right of entry is concerned, the Amending Act repeals amendments requiring the employer to provide the union official with transport and accommodation to remote locations. It repeals amendments nominating lunchrooms as the default union discussion location, and it expands the Fair Work Commission's capacity to deal with disputes about the frequency of union visits to premises to hold discussion. Further, the union must be covered by an enterprise agreement that applies to work performed at the premises, or if no enterprise agreement applying to the organisation, an eligible person, being somebody who is eligible to join the union, must have invited the union onto the premises before the right of entry can be exercised. And lastly, just in regard to unfair dismissal, subject to certain conditions, the Fair Work Commission will not be required to hold a hearing or conference when determining whether to dismiss an unfair dismissal application under Section 399A of the Act. They will do so if the applicant failed to attend a conference conducted by the Fair Work Commission or a hearing held by the Fair Work Commission in relation to the application, or failed to comply with the direction or order of the Fair Work Commission relating to the application, or failed to discontinue the application after a settlement agreement has been concluded. Excuse me. The explanatory memorandum to the Act gives the Commission the power to dismiss an unfair dismissal application without a conference or hearing, but it is only to be exercised in very limited circumstances where the Fair Work Commission is satisfied of unreasonable conduct on the part of the applicant. Before exercising the power, the parties must be invited to provide further information. A right of appeal is maintained, so an employee who has had their application dismissed under that provision can appeal that decision to a full bench of the Commission. That concludes the presentation. I don't know if we have any questions.
No.
Right.
No, they're available. If anybody has any questions, could you please ask them now, and we'll endeavour to answer them for you. All right. right, well, thank you very much for participating in this webinar, and if you have any questions, please don't hesitate to contact us. Thank you.